Next matter to come before the court this morning is appellant Jasmine Norman versus Tri-Arch Incorporated. Good morning.
Good morning.
Each party will have 15 minutes in which to present their case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to retain some of that time, let me know when you come up to the front podium. I'm keeping track of the clock and will keep your price as fast as you can.
Okay.
We are being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We have read your briefs and we're ready to proceed when you are.
Thank you. May it please the court, my name is Patrick Henry. I'd like to reserve 3 minutes for rebuttal, please.
Thank you.
And I do represent Ms. Norman in this case, the plaintiff. If you read the briefs, you know this was a slip and fall in McDonald's that happened in early March 2015. She went through the drive-thru and ordered coffee and then was told there was no coffee, so was put in the designated waiting area and developed the need to go to the bathroom. She walked into the bathroom. According to her testimony, spent 3 to 4 minutes in the bathroom, walked out of the bathroom, and as she was coming back around the corner past the front counter, slipped and fell, sustaining injuries to her body.
Counsel, before we begin with the actual facts, there's also an issue of whether or not this is proper order before us with the John Doe defendant. Was the John Doe defendant ever served?
No, they were not, and I did some briefing back and forth with the magistrate at the appellate court. Basically, the 1 year had passed to serve the John Doe appellant, and so they were basically thrown out as our position. And so the trial court said it was a final appealable order, I think based on the fact that a year had passed in between the time of the filing with the John Doe defendant. But they were never served, to answer your question.
But they were tempted?
No, I believe they were just put on as a precaution because we weren't sure. The first filing of the complaint had McDonald's itself, the corporation, as the defendant, and we weren't sure whether there was going to be a franchise or another party interest, and in fact there was. So it was quickly amended. An amended complaint was filed, I think, within a few days of the month of the filing of the original complaint. So I'm not sure if there was ever an intent to serve the John Doe defendant.
Thank you.
Anything? Okay. So the trial court granted summary judgment based on the idea that the danger was open and obvious, and thus the defendant owed no duty of care to Ms. Norman. Quoting the decision, the facts support that due to the weather conditions, the floor of the establishment was wet and being dry mopped. Further, tall yellow caution cones were placed directly in front of each doorway, which the plaintiff would have noticed had she paid attention when she entered the establishment. So the basis of our appeal is based on 2 things, basically, that the evidence was not weighed properly in favor of the non-moving party, and that the law was then misapplied. In terms of whether or not the cones were on the floor, my client testified that she did not see any cones when she walked in. The court and the defendants pointed out how the one warning sign was directly in front of the door. It would have been impossible to miss had it been there when she was walking in. And the video only shows the minute or so while she's in the bathroom, not when she actually walks into the McDonald's. So we just frankly don't know whether the signs were up or not. She testified she did not see them. They have an employee who testified that they were up, but again, we requested the entire tape, only to be told that the entire tape doesn't exist. So for the purposes of summary judgment, we're arguing that it should have been held that there was no signs up when she walked into the establishment. The second major issue has to do with the weather. Ms. Norman testified unequivocally that it was dry outside. The defendant in the court found that it was snowy and wet outside, based in large part on a weather report that was subsequently printed up and submitted with defense motion for summary judgment. The only thing I will note on that is that the weather report was taken at the Lorain County Regional Airport, which sits 9 miles due south of the McDonald's. And as in Northeast Ohio my entire life, I can say that just because the weather was snowing 9 miles further away from the lake does not mean it was snowing 9 9 miles further north. So I feel, our argument is that Ms. Norman's testimony that it was dry outside and not snowing should have been considered and found for the purposes of summary judgment. Now, the reason that these are both so important is because on the open and obvious doctrine, as this court has recently pointed out in McClown versus Coventry Township, which I realize is a different set of circumstances, but it did deal with the open and obvious doctrine, said that we must look to the totality of the circumstances, considering both the nature of the dangerous condition and any attendant circumstances that may have existed at the time of the injury. There was no precise definition of attendant circumstances, but the phrase encompassed, quote, all facts relating to a situation such as time, place, surroundings, and other conditions that would unreasonably increase the typical risk of a harmful result of an event. So obviously the fact of whether or not it was wet outside would be an attendant circumstance, because if it was snowing outside, one would be more cautious about walking into a McDonald's with the floor potentially being wet. Same thing with the warning signs when you walked in. The video that is present shows for about a minute McDonald's employee mopping the floor. I don't know if you had a chance to see the video. It was included with the transcript, but seconds before my client walked out of the bathroom, there is a warning, there's one warning sign around by the front door where she walked in. Her position is that was not there when she walked in. I don't think that anybody would argue that she could have seen that one as she exited the bathroom in the back of the McDonald's, because it was located around the wall and around the counter. The second sign is located next to a white pillar, the support pillar structure inside the McDonald's. She says she didn't see it. To me, watching the video, but I'm obviously biased, there's a question of fact of whether it was observable from where she was walking or not out of the bathroom. What we can tell for sure is that it wasn't located on the area where he was clearly mopping just seconds before she falls. I mean, the floor, it's probably 15 seconds. He walks by with the mop, then walks back with the mop, no bucket, and goes back to the front of the store. She walks out, slips and falls. So our argument based on the totality of the circumstances and using Louderback versus McDonald's, which is a 4th district case, with similar facts, the general rule appears to be that plaintiff can show that the premises owner's employee recently mopped the area where the plaintiff fell and failed to adequately warn customers of the slippery conditions and genuine issues of material fact exist. So I'm not debating whether, obviously, open and obvious doctrine is a strong doctrine. I'm not debating that exists. I'm saying that the court misweighed the evidence and had it weigh the evidence in a way most favorable to Ms. Norman, then I believe a reasonable juror could have found that there was not sufficient warning given the circumstances. Another attendant circumstance is that she had just walked through the McDonald's minutes before. And I know that this was challenged and will be challenged here momentarily, but if you're looking at the totality of the circumstances and somebody has just, you're supposed to, and there's plenty of case law saying you're supposed to be aware of your surroundings and look for dangers, and if something's open and obvious, then the property owner doesn't have a duty to protect you. But if she just walked through that area minutes before and encountered no danger, saw no signs of danger, and walked right back through, I don't believe that she would have had any reason to expect it. There's actually a hypothetical in Louderback which deals with this exact situation. It says the proprietor has caused the floor to be washed while patrons are still on the premises, has impliedly assured said patrons that the floor is safe for them to pass over and may incur liability if a patron is injured by a fall while attempting to navigate the premises. Thus, if the McDonald's employee had mopped the floor while Miss Ashley was in the restaurant would have had a duty to give warning of any slippery or unsafe conditions caused by the cleaning. So our position, and I think I'm probably done early here, is that reasonable questions of fact exist as to whether or not there was sufficient warning to the wet conditions for Ms. Norman.
So I have a question in regard to this. We have not been able to watch the video yet, but we definitely will.
Okay.
When we come up here, we pick up the record and go through everything. But in the video, I know there's some disagreement as to what it does show and what it doesn't show, but in the video, is there anything that shows that the employee that was mopping did have a bucket?
I did not see a bucket. Kind of goes from the front of the screen to the back of the screen, and I can't see a bucket to answer your question. There may be one he's further away, but I couldn't make it
So you
out.
couldn't tell if there was water in the bucket or not?
To me, it appears that the floor is becoming wetter as he's mopping it. The areas he goes over, there's a glisten or a gleam where there wasn't before he started mopping it. His position is that he was dry mopping, meaning
Sure.
people were bringing in the water from the outside, which is why it's so important whether or not it was snowing or not. Because obviously, if he's dry mopping, my understanding is, the floor is wet and you're just you're using a dry mop to.
That's why I was
It's
asking
safer.
about the bucket, if there was a bucket, if there's water in the bucket.
Yeah, Your Honor, I can't see a bucket in the video.
You'll have 5 minutes for rebuttal.
Thank you.
May it please the court, my name is Jay Hansen, and I have the privilege of representing the appellee in this matter, Tri-Arch Inc. Basically, we agree with the appellant's recitation of the facts. What we believe this issue in this appeal and in the entire case is whether there were wet floor signs present in Tri-Arch's restaurant on March 1st of 2015, and whether that constitutes an open and obvious condition. Tri-Arch obviously maintains that it was an open and obvious condition, especially because there were 2 wet floor signs. And Judge Carr indicated that you will watch the video. It's not very long, but it is very telling. A picture is worth 1,000 words. And it's also interesting to note that as Ms. Norman is coming out of the restroom, the employee was just to the side of the pillar with a mop. And this pillar is right by the door, and the warning cone is just next to it. It is not behind it to obscure its view.
Was he behind the pole
No,
so she could see him
yes,
with
Yes.
the mop?
yes,
You can see that in the video.
it's, I can. Yeah.
When she comes out of the restroom, isn't he all the way across the restaurant,
I believe.
walking away from the
If-
restroom?
I just looked at it this morning again. If I remember correctly, he had just been over to the side of the pillar and say the pillar was maybe 5 feet away. He was on this side of the pillar when she fell. And so there's the pillar, the cone right next to it, and Mr. Hoskins, who was dry mopping, which is another issue. I did not see any bucket in the video, and Mr. Hoskins testified that he was actually dry mopping because the floor was wet from people bringing in snow from the outside. Now, appellant's argument is all about, well, not all about, but a lot about the weather report that we submitted with our motion for summary judgment. Now, I don't know of any way to actually pinpoint what the weather was on at that exact location, at that exact time. Ms. Norman testified that the accident occurred between 10 and 1, 11 and 1, I apologize, in the afternoon. So there's no way that I know of to actually pinpoint what the weather was at that exact location at the exact time that she walked into the McDonald's. But to answer Judge Hensel's question, yes, I believe he's visible even if from around the corner. He's a big man mopping the floor and there's clearly a warning cone just to the side of the pillar.
Counsel,
Yes.
your other side here is saying that video does not show what the conditions were when she entered the restaurant, only when she exited the restaurant.
That is true, and it is about a minute, and then you see her walking from the restroom in kind of a hurriedly pace. We requested the entire video. Apparently, I can't explain why we only got that portion. We didn't destroy it. I don't believe my client did either. So what we have is what we have, unfortunately. But the video does clearly show, I believe, that there was plenty of warning to her, not only because it was snowing and icy outside and that floors were wet, but also that there's a cone and then there's a person dry mopping and making, you can see in the video that the floor is glossy. And as this court knows, I think that the leading case in Ohio is Armstrong versus Best Buy, which I cited a lot in my brief, that still holds that the open and obvious rule is still alive in Ohio. And with that, there is no duty on a premises owner to ensure the safety of a patron. Now, if you could put 1 million signs out, and anybody can say, well, I didn't see any of those. And that was also dealt with by, not that particular cone issue, but in Greenie versus the Ohio Turnpike Commission, that where there is evidence of a warning sign, or the fact that it is an open and obvious condition, just self-serving testimony does not create an issue of fact. The Ohio Supreme Court stated that in Greenie. The question comes, Ms. Norman says, I didn't see any, or there were no cones. And the issue is not whether or not she saw them, whether or not they were visible. I don't believe that Mr. Hoskins magically put them there between the time that she walked in and between the time she walked out. Regardless, when she's walking out, that warning cone is directly in her line of vision, and it is observable. And that is a standard. Not whether the appellant saw it, but whether it's observable or not. It's Tri-Arch's position that it was observable, making any condition an open and obvious condition. And because of Armstrong versus Best Buy, then that open and obvious condition obviates any duty by Tri-Arch to ensure her safety. Slip and falls happen all of the time, unfortunately. And that is why the courts have required the premises owners to adequately warn the patrons in restaurants. To make, it seems just incongruous to me to actually have to stand out there and say, there's a wet floor sign there, or there's a wet floor here, don't go there, don't go there. The cost of fast food would just rise if you have that. But the courts say that if there is enough warning, which there was in this case, and I think you'll see that on the video, there is no duty to ensure her safety. She has a duty herself to be aware of her surroundings. She testified that she was in a hurry to get to the restroom because she had to go to the restroom very, very badly. She stopped briefly to talk to one of her friends that was at the counter, then continued on to the restroom. She also said that she was in a big hurry to get out of the restaurant so she could get her coffee for her aunt. You can see in the video that she is kind of racing to get around that corner. And nobody expects her to fully examine the floors, which is why they have tall, yellow caution signs to get somebody's attention. Those are observable. Personally, I don't know if I've ever been in a McDonald's where I haven't seen a wet floor sign or somebody mopping. She has testified that she was at that McDonald's several times in the past before this incident occurred. We submit that her own actions by not paying attention to look at these cones, these safety cones, these warning cones, which were clearly out, obviates any duty on the part of Tri-Arch towards Ms. Norman in this case. For that reason, we respectfully request that this court affirm the trial court's grant of its motion for summary judgment. Thank you.
Thank you.
I wish I would have, I didn't know if we could play the video or not, I would have saved a lot of, but I guess if you guys had the opportunity. Because I watched it yesterday before I left, and my recollection is that Mr. Hoskins first walks into the frame of the video, mops, goes to the area where he describes next to the pillar, but immediately before the fall comes back, and when she falls, I'll stay on the camera, he's up against, it looks like he's looking at his phone as he walks away, and you can watch the video, and is up with his back to her against one of those stand-up tables near the door where she walked in, not observable to her as she walked into the restaurant. But I could be messing up the order of, those are the two basic things he did. But my understanding is that the mopper was not observable, but again, that what he described also happened, so I could be, you know, a picture is worth 1,000 words. It's also, you gotta also ask what is not on that video. And what is not on that video, had it supported them, I have a feeling would have been presented to us. I don't understand why they would save only the 1 minute where the signs were up. Again, she testified that it was 3 to 4 minutes when she was in the bathroom. There's plenty of time to plop up one of those warning signs. It takes about 5 seconds to just fold it out. And in terms of whether it's observable or not, I understand the case law is heavily against us. But there is an important distinction in Kidder, which is quoted a lot. But Kidder talks about, it's not whether the sign is observable to anybody. Kidder, there's a wet floor warning sign in a grocery store at the end of an aisle. And the plaintiff is walking down the aisle and steps around, you know, like the end of an end cap. And on the first step, slips and falls. And the defendant says, well, we had a wet floor warning sign up, it was open and obvious. And the court differentiates and says, the question is whether it's observable to that specific person on that specific path of travel. And so, to me, there are questions of fact, and you'll see when you watch the video, whether or not that warning cone is observable to Ms. Norman as she, from her specific path of travel, as Kidder talks about. That was all that I had in rebuttal, unless there's any questions.
Seeing none, thank you both for
Thank you
the
very much.
presentation.
Thank you.
Court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted to our website as well as Supreme Court.
Thank you.
Thank you, Your Honor.
Thank you.